student here at Albany.
Hi, I'm Amber Quinn. I'm an 11th grade and 12th grade social studies teacher from Shenandoah.
Can you please, well, you have your name tags, but still, please introduce yourself.
Good morning, Your Honors. My name is Justin Smith, and along with my colleagues Tyler Hammond and Alex Eagle, I will be presenting along with them for Team Jefferson today.
You guys are unit 4, and we'll be addressing this question. How? Sorry. And we'll be addressing the question, how has the Constitution been changed to further the ideals contained in the Declaration of Independence? We'll let our Chief Judge start us off.
Your question for today, are you ready? All right, take a deep breath. We're not that intimidating, are we? We can be. Are you ready? Okay. The question for today, specific question, is throughout American history, courts have played a major role in the development of public policy through the exercise of the power of judicial review. What is judicial review? And how have the courts used this power to develop public policy? In specific, the single most important post-1787 addition to checks and balances is judicial review. Do you agree or disagree with this view? Why or why not? And the second point you need to cover is why has judicial review continued to be so controversial, even this year, even this week? Okay, you ready? Mr. Timer?
Judicial review is the ability of the judicial branch to review and determine the constitutionality of the acts of the other two branches of government, the executive and the legislative. Judicial review is not a power expressly given to the Supreme Court by the Constitution. The court's very capability of judicial review is based on a precedent set by itself. The 1803 decision in Marbury v. Madison established that the court had the ability to review the constitutionality of actions of the executive and legislative branches. The American public's acceptance of this decision has led to the long-standing tradition which we today recognize as a key part of checks and balances. Throughout the history of the United States, using the practice of judicial review, the Supreme Court has been able to have an influence on public policy. For example, the 1973 decision in Roe v. Wade was one that overturned many state statutes that were already in existence, such as the Texas law making it illegal to help any person perform an abortion, which Dallas County District Attorney Henry Wade defended.
Personally, I agree with the statement. The judicial branch has very few enumerated powers listed explicitly in the Constitution, and almost no ability to check the actions of the other two branches. While self-claimed, the power of judicial review is necessary to maintain true separation of powers. The Supreme Court is the one branch which does not have to face accountability at the polls. Therefore, its decisions will be less influenced by politics and more focused on upholding the principles of the Constitution.
Judicial review has remained a controversial part of the Supreme Court because it lacks a specific constitutional basis. There is no language in Article 3 or any other article of the Constitution which directly provides for this power. The power also makes it difficult for other branches of government to check the Supreme Court. The only way to reverse a Supreme Court decision are a constitutional amendment or a subsequent Supreme Court decision overturning it, both of which are extremely rare. Judges are also appointed rather than elected and sit for life terms. Poor decisions by the Supreme Court have also contributed to the controversy over judicial review. Decisions such as the 1857 Dred Scott case, which ruled that people of African descent were not citizens of the United States and never would be. The 1896 decision in Plessy v. Ferguson, which upheld the doctrine of separate but equal. The 1944 Korematsu decision, which upheld the constitutionality of placing Japanese Americans in internment camps during World War II. Or the 2005 decision in Kilo, the City of New London, where the court upheld the constitutionality of a municipality taking private property by eminent domain to benefit a private developer, citing that this kind of development would constitute public good through tax revenue and economic development.
The Supreme Court's prime mission is to uphold the Constitution and provide a check for the other two branches of government, provide the body with an important role in public policy, and a large amount of influence in federal production of laws. Judicial review brings accountability to the federal government, as well as means for the Constitution to remain, quite literally, a living document with the ability to be interpreted differently as new challenges arise. Thank you, Your Honors. I believe we're now ready to take your questions.
Okay, any time left will be added to your 6 minutes for follow-up questions.
Tyler, I actually love that you talked about Kelo. That's one of my favorite cases. Can you talk to me a little bit about what you think the public policy implications are in terms of eminent domain in that case going forward?
Well, the issue with eminent domain in the Kelo case is that previously the uses for which the government had for eminent domain were relatively limited. It's an extraordinarily powerful exercise by the government and could be used for fairly specific circumstances. Airports, things that were generally viewed as an absolute necessity for the government, in particular for national defense reasons. The Kelo case expanded the power of eminent domain to be used to remedy blight. The Supreme Court doesn't go into a lot of definition of exactly what this blight is, but governments have later taken this to mean that they can use eminent domain in almost any case in which it would ultimately benefit the surrounding neighborhood, usually in the form of more revenue.
Another follow-up question to, I'm not sure which one you mentioned it, was that in order to overturn a precedent-setting case, you need to either have a constitutional amendment or another precedent-setting court decision. Can you give us some examples? You've mentioned a number of cases that support judicial review, but can you give us a couple of cases where judicial review has been checked by those two methods?
I would cite the 1857 Supreme Court decision in Dred Scott v. Sanford, in which the Supreme Court, led by Chief Justice Roger Taney, ruled that African Americans were not citizens of the Republic and never would be. Later brought on by increasing tensions between abolitionists and supporters of slavery, the Civil War occurred. After the Civil War, the 13th Amendment was passed, which freed all slaves in the United States, both in the southern part and in the states which had remained loyal to the Union.
Are there any other situations where
I think another,
precedent-setting court decisions have been overturned?
I have another example where someone had overturned the same decision, Elizabeth Briggs. I think Dred Scott, the 14th Amendment, which gave all people the right to vote, I think was also another amendment which overturned the same decision. And I think there are other examples too of different pieces of legislation and decisions which all work to overturn maybe one or two bad decisions in this court's history.
Perhaps not such a dramatic reversal as we saw with the Dred Scott decision, but I would point to the endless legal wrangling over the Supreme Court's decision in Roe v. Wade. Because the Supreme Court is so difficult to overrule, and because on such a highly polarized issue, the odds of a constitutional amendment are so minuscule as to be nothing. This has led to basically the Supreme Court having to arbitrate endless series of disputes over the original decision. And we have seen, again, not so much a reversal, but we have seen shifts in the Supreme Court's policy here.
Along that lines, where you definitely think that there's a minuscule chance of an amendment, do you think the executive and legislative branches should also possess the power to declare what the Constitution needs per se? Why or not?
Well, all members of the federal government swear an oath to uphold the Constitution, and I think that in some respect they do have that responsibility. I don't think that they should have the same ability to declare something unconstitutional as the judicial branch, because that is the judicial branch's function, is to check the other branches and make sure that they follow the Constitution.
I would point to the Supreme Court case in 1974, U.S. v. Nixon, which President Nixon tried to use the doctrine of executive privilege to state that he could keep several White House tapes from being exposed to the House Committee on his actions during the Watergate scandal. And the problem with this is that when our elected officials start determining what the Constitution is, they may start to interpret it specifically for their own benefit, for their own re-election, for aims which do not specifically uphold the Constitution itself.
Perhaps somewhat more mundane reason for giving this power to the Supreme Court is the fact that the 9 justices are, although they may disagree, 9 of the finest legal minds in the nation. I don't know if the average congressman or senator or even president has the experience or a staff with the necessary experience to make decisions of that nature.
Do you think the concept of judicial review, the latest case you mentioned, 1975, is still pertinent today?
I would say absolutely. Judicial review itself, it continues to be a factor in many laws which are passed. I would point to the Supreme Court decision just this past week, which outlawed or declared unconstitutional, rather, parts of the McCain-Feingold campaign finance reform. While judicial review may seem to be an antiquated institution, its use last week to declare part of a law unconstitutional shows that it is an evolving and changing part of the American democracy.
A quick follow-up to that. Because the split on the bench was so hotly contested, what do you see in the future in terms of the potential overturning of this case, or maybe anything legislative that might impact public policy going forward?
I believe that as the Supreme Court shifts, as my colleague mentioned earlier, as the Supreme Court shifts from conservative to liberal and back to a more moderate stance, there are obviously going to be changes that are made according to this decision, specifically dealing with campaign finance. It's definitely hard to predict what could happen in the future. However, I do see Congress trying to re-implement these kinds of laws with the hope that the Supreme Court will give them a more favorable. Maybe they won't use the same exact language that they had used before. Maybe they'll try to amend some of the language to make it more acceptable to the Supreme Court. But I do see Congress trying to pass this law again and have it declared constitutional if the issue ever arises.
Wait a second. Talking about Andrew Jackson and his refusal to follow the Supreme Court decision in Georgia v. Worcester. What do you think should have happened? Should there have been penalties for Andrew Jackson?
The problem with attempting to enforce the Supreme Court decision is that the executive branch is explicitly given the power to enforce laws. So when the executive branch, which in this case was Andrew Jackson, decided not to enforce this law, as I believe he said, let me paraphrase, the Supreme Court has made its decision, let us see them enforce it. I'm sorry, I see our time is up. May I briefly conclude?
Yes.
Yeah, please.
The Constitution does not provide a remedy for this kind of circumstances. The founding fathers either never foresaw or just didn't write out any way to punish the executive for something like this, hence Jackson's escape relatively unscathed.